Hello friends, welcome to KRK-Law channel. Friends, today we will see Post of District Judge Judicial Preliminary Exam previous question paper with answer in 2011. So friends, watch our complete video, like it, share it, comment on it. Don't forget to subscribe our channel. Friends, we will see question paper dated of 24 July 2011. Question number 1. The extension of period of limitation on the ground of legal disability available under section 6 and 7 of the Limitation Act is not applicable to suits dash. Answer is option number A, to enforce right of preemption. Question number 2. When one's time has begun to run dash. Answer is option number A, subsequent disability to institute the suit will not stop it. Question number 3. Presumption under section 20 of the Prevention of Corruption Act 1988, where public servant accept gratification other than legal remuneration, is not applicable in a trial for an offence punishable under dash. Answer is option number C, clause E of subsection 1 of section 13. Question number 4. Under section 7 of the Prevention of Corruption Act 1988, the word gratification dash. Answer is option number C, is not restricted to pecuniary gratification or to gratification estimable in money. Question number 5. A protection order made under section 18 of the Protection of Women from Domestic Violence Act 2005 shall be in force till dash. Answer is option number C, the aggrieved person applies for discharge. Question number 6. Which formality is essential for a valid adoption? Answer is option number C, actual giving and taking. Question number 7. Under Muslim law, a daughter as a residuary takes dash. Answer is option number C, half the share of the son. Question number 8. If a Mohammedan marries a fifth wife when he already has 4 wives living, the marriage is dash. Answer is option number C, irregular. Question number 9. Under Hindu law, a karta of the joint family can alienate the property dash. Answer is option number C, for both legal necessity and benefit of estate. Question number 10. If a legacy is given to two persons jointly and one of them dies before the testator dash. Answer is option number A, the other legatee takes the whole. Question number 11. No probate of will shall be granted until after the expiration of dash clear days from the day of the testator's death. Answer is option number A, 7. Question number 12. The report of the probation officer is considered to be dash. Answer is option number B, confidential. Question number 13. Rights to do acts necessary to secure full enjoyment of an easement are called dash. Answer is option number D, accessory rights. Question number 14. A check is a bill of exchange drawn on a specified banker and not expressed to be payable. Answer is option number B, otherwise than on demand. Question number 15. Under Negotiable Instrument Act 1881, where no rate of interest is specified in the instrument, interest on the amount due thereon shall be calculated at the rate of dash per centum per annum. Answer is option number D, 18. Question number 16, cancelled. Question number 17. In a contract of sale of goods, the breach of warranty gives rise to dash. Answer is option number C, a claim for damages. Question number 18. Under the General Clauses Act 1897, district judge shall dash. Answer is option number B. Mean the judge of a principal civil court of original jurisdiction. Question number 19. The principle of sustainable development relates to dash. Answer is option number D. Environmental law. Question number 20. A opens a coaching class in front of B's coaching class. Majority of the student of B shift to A. The situation will be governed by which one of the following principles? Answer is option number B. Damnum sine injuria. Question number 21. The rule of strict liability was enunciated in whole in which one of the following cases? Answer is option number D. Reland versus Fletcher. Question number 22. Where the death of a bodily injury to any person gives rise to a claim for compensation under Motor Vehicle Act 1988 and also under the Workmen's Compensation Act 1923, the person entitled to compensation may claim such compensation. Answer is option number C. Under either of those acts. Question number 23. Suppressio veri means. Answer is option number B. Suppression of truth. Question number 24. Res nullis means. Answer is option number B. Things belonging to no one. Question number 25. Necessitas non habet legem means. Answer is option number B. Necessity knows no law. Directions. The following 1 to 8 atoms consist of two statements, one labeled as the assertion A and the other as reason R. You are to examine these two statements carefully and select the answers to these atoms using the codes given below. Codes. Number A. Both A and R individually true and R is correct explanation of A. Number B. Both A and R are individually true but R is not the correct explanation of A. Number C. A is true but R is false. Number D. A is false but R is true. Question number 26. Statement 1. In an action for malicious prosecution, it must be proved that the defendant had initiated criminal proceeding maliciously and without reasonable and probable cause. Statement 2. Action for malicious prosecution cannot succeed unless the plaintiff proves that he suffered special damages. Answer is code number C. Question number 27. Statement 1. A registered document shall operate from the time which it would have commenced to operate if no registration thereof had been required or made, and not from the time of its registration. Statement 2. If two registered documents are executed by the same person in respect of the property in favor of two different persons at different times, the one which was executed first has priority, while the other, although the former was registered subsequent to the latter. Answer is option number A. Question number 28. Statement 1. If any person is dispossessed without his consent of immovable property, otherwise than in due course of law, he may by suit under section 6 Specific Relief Act recover possession thereof without reference to the question of title. Statement 2. Section 6 preclude institution of a suit to establish title to such property and to recover possession thereof. Answer is code number C. Question number 29. Statement 1. The specific performance of any contract may be in force when the act agreed to be done is such that compensation in money for its non-performance would not afford adequate relief. Statement 2. The court shall presume that the breach of a contract to transfer immovable property cannot be adequately relieved by compensation in money. Answer is code number A. Question number 30. Statement 1. The period of limitation for a suit for possession of immovable property based on previous possession and not on title when the plaintiff while in possession of the property has been dispossessed is 12 years. Statement 2. The period of limitation for such a suit begins to run when the possession of the dependent becomes adverse to the plaintiff. Answer is code number C. Question number 31. Statement 1. In case the sole plaintiff dies and no application is moved to bring the legal representative within the statutory period, the suit shall abate. Statement 2. The death of such plaintiff, even between the conclusion of hearing and the pronouncing of the judgment, results in abatement. Answer is code number C. Question number 32. Statement 1. The Supreme Court is a court of record. Statement 2. The judgment of the Supreme Court are reported in law reporters. Answer is code number B. Question number 33. Statement. Any private transfer of the property attached in execution of decree shall be void as against all claims enforceable under the attachment. Statement 2. The bar applies to any private transfer of the attached property even made in pursuance of any contract entered into and registered before the attachment. Answer is code number C. Question number 34. In the cases of consecutive sentences on conviction for several offences at one trial by a metropolitan magistrate, the aggregate punishment dash. Answer is option number A, shall not exceed twice the amount of punishment which the magistrate is competent to inflict for a single offence. Question number 35. If the accused, though not of unsound mind, cannot be made to understand the proceedings, and if such proceeding result in a conviction, the final order has to be passed by dash. Answer is option number D, the High Court. Question number 36. Statement of witness recorded under section 164 of the Code of Criminal Procedure can be used dash. Answer is option number C. Both are corroboration and contradiction. Question number 37. As per section 468 of the Code of Criminal Procedure, the period of limitation for an offence punishable with imprisonment for a term of 2 years is dash. Answer is option number C, 3 years. Question number 38. The statement of fact stated by an accused in an application for plea bargaining dash. Answer is option number C, cannot be used for any other purpose except for the purpose of plea bargaining. Question number 39. Court can take cognizance of an offence punishable under section 498A of the Indian Penal Code even if the complaint is made by dash. Answer is option number A, brother of the aggrieved person. Question number 40. An application for maintenance under section 125 of the Code of Criminal Procedure by the father against his son has to be filed in any district where dash. Answer is option number A, the son resides. Question number 41. In an appeal from a conviction, the appellate court cannot. Answer is option number C, alter the extent of the sentence so as to enhance the same. Question number 42. Which one of the following does not amount to criminal conspiracy dash. Answer is option number C, an agreement to do an illegal act without doing any act to carry out that agreement. Question number 43. To constitute the offence of kidnapping from lawful guardianship in respect of the person of unsound mind, the outer age limit is. Answer is option number D, not prescribed. Question number 44. A is attacked by a mob who attempt to murder him. He cannot effectually exercise his right of private defense without firing on the mob, and he cannot fire without risk of harming young children who are mingled with the mob. A fires and harms one child. Which one of the following is the liability of A? Answer is option number A. A commits no offense as he exercises right of private defense. Question number 45. A instigates B to murder C. B refuses to do so. Which one of the following is the liability of A? Answer is option number C. A is guilty of abetting B to commit murder as to constitute abatement. It is not necessary that the act abated should be committed. Question number 46. X intended to kill A but instead killed B, whom he had no intention to kill. Under which doctrine X is liable for the murder of B? Answer is option number B. Doctrine of transfer of malice. Question number 47. A lays sticks and turf over a pit with the intention of causing death or with the knowledge that death is likely to be thereby caused. Z, believing the ground to be firm, treads on it, falls and is killed. 47 number is cancelled. Question number 48. A 17-year-old boy, by instigation voluntarily causes Z, a girl under 18 years of age, to jump off a 50-meter bridge into sea. Z jumps and dies. Choose correct answer. Answer is option number B. A abetted suicide by Z. Question number 49. A's wallet falls out of his pocket, unknown to him. His friend B, who sees this, picks up the same. On finding that the wallet contained rupees 2000, B uses the money for his own purposes. After 6 hours, B puts rupees 2000 back in the wallet and returns the same to A. B is guilty of, answer is option number C, criminal misappropriation of property. Question number 50. X is an agent for Y. There is a contract between X and Y that all sums remitted by Y to X shall be invested by X according to Y's direction. Y remits rupees 10 lakh to X with a direction to X to invest the same in infrastructure bonds. X dishonestly disobeys the direction and puts the money in his own business with a hope that the investment will generate more profit. Answer is option number X has committed. Answer is option number C, criminal breach of trust. Question number 51. A fresh suit in respect of the same cause of action is permissible. Dash. Answer is option number B, where a suit is dismissed under Order 9, Rule 3. Question number 52. A party dissatisfied with an order of injunction may move the court which passed the order for. Answer is option number D, all of the above. Means option number A, setting aside the order. Option number B, discharge of the order. Option number C, variation in the order. Question number 53. In a suit for restraining the defendant from committing a breach of contract, the court may grant temporary injunction restraining the defendant from committing the breach of contract. Answer is option number C, either before or after judgment. Question number 54. A claims a sum of money as due to him from X or Y, and in a suit against both obtains a decree against X. X appeals and A and Y are arraigned as respondents. In the above situation, the appellate court, number 1, can decide in favor of X and pass a decree against Y. Number 2, can decide in favor of X and only dismiss the suit. Choose the answer using the correct code. Answer is option number C, both 1 and 2. Question number 55. A continuing guarantee may at any time be revoked by the surety. Answer is option number B, as to future transaction. Question number 56. Which one of the following constitutes an offer? Answer is option number B, advertisement announcing a reward of rupees 1 lakh to any person who finds the missing son of the advertiser. Question number 57. Which one of the following statement is correct? Answer is option number D. An agreement made without consideration is a contract if it is a promise to compensate a person who has already voluntarily done something for the promiser. Question number 58. Which of the following statement is our correct? Answer is option number C, 1 and 2. Means number 1. When consent to an agreement is caused by undue influence, the agreement is a contract voidable at the option of the party whose consent was so caused. Number 2. Where both the parties to an agreement are under a mistake as to a matter of fact essential to the agreement is void. Question number 59. Which of the statement given below is are correct? Answer is option number A, 1 only. Number 1. An agreement without consideration in writing and registered made on account of natural love and affection between parties standing in near relation is a valid contract. Question number 60. A person who finds goods belonging to another and takes them into his custody is subject to the same responsibility as dash. Answer is option number C, a bailee. Question number 61. No consideration is necessary to create. Answer is option number C, an agency. Question number 62. X, a publisher of a newspaper, agrees to publish at Y's request a defamatory article in respect of Z, as Y agrees to indemnify X against the consequence of the publication in a suit by Z. X has to pay damages and incur expenses. Which one of the following is the correct statement regarding to the liability of Y? Answer is option number B. Y is not liable as the act was criminal. Question number 63. In which of the following situation is there stipulation by way of penalty? Answer is option number C, both 1 and 2. Question number 64. Consider the following statement with regard to the consequence of breach of contract. Answer is option number A, 1 only. Means in case of breach of contract, the party who suffers is entitled to receive compensation for any loss or damage caused to him, thereby which the parties knew when they made the contract to be likely to result from the breach of it. Question number 65. In which of the following situation is the surety discharged? Answer is option number A, 1 only. Means A becomes surety to C for B's conduct as a manager in C's bank, afterward B and C contract without A's consent, and that B shall become liable for 1/4 of the losses on overdraft. B allows a customer to overdraft and the bank loses a sum of money. Question number 66. An outgoing partner of a firm dash. Answer is option number C, may carry on a business competing with that firm. Question number 67. Under the Transfer of Property Act, immovable property includes dash. Answer is option number D, none of the above. Question number 68. Every transfer of immovable property made without consideration with intent to defraud a subsequent transferee shall be dash. Answer is option number B, voidable at the option of subsequent transferee. Question number 69. For application of the doctrine of part performance, the agreement to transfer an immovable property must be. Answer is option number D, in writing, signed and registered. Question number 70. A gift comprising both existing and future property is dash. Answer is option number C, void as to the future property. Thank you friends, and remaining part next video.